This is Ray Brescia on Legal AF, part of the Midas Touch Network. I teach at Albany Law School, but all of the opinions expressed here are my own. If you like what you hear here and other parts of the network, please like, subscribe, and share as you feel motivated to do so. So I'm going to talk today a little bit about the efforts to go after some of the president's perceived enemies. We've seen some really important developments this week in the dismissal of the cases against former FBI Director Comey and current Attorney General James of New York. Those dismissals were without prejudice, which means in some respects, perhaps the DOJ will bring them again, or certainly it looks like they're going to appeal them. We also heard that the FBI is actually investigating some of the efforts of federal agents and potentially non-federal agents in the investigations of people like Senator Schiff. But this week we also learned yesterday, I'm recording this on Wednesday, the 26th, that yesterday Congressman Eric Swalwell filed an affirmative case. So he has filed a civil action in the district court in DC against the investigation claim against him, which also claims, like some of these other individuals who are the target of the Trump administration's retribution, they claim that he also engaged in mortgage fraud. So the way these cases, as is alleged in the complaint and as public reporting suggests, these cases have developed because the head of the Federal Housing Finance Agency, Bill Pulte, has scoured records within different federal agencies that have them regarding virtually every American who has a mortgage, their records. He scoured those records, again, according to allegations in the complaint and in public reporting. He scoured those records and looked for evidence of mortgage fraud. We understand that that is likely how the evidence, such as it is against Attorney General James, came about, and other individuals like Lisa Cook of the Federal Reserve Board. So Swalwell claims that this has occurred with respect to him, and that that this violates both the Federal Privacy Act of 1974 and the First Amendment. So let's get into some of these allegations that Swalwell puts in his complaint. So first, the Federal Privacy Act of 1974, which was enacted in the wake of Watergate, right, when there were fears that the president was using, President Nixon had been using, elements of the federal government to go after his political enemies. This is just one of the laws that were put in place after Watergate, and it makes it illegal for anyone maintaining a federal system of records, and the relevant records here are covered by this law, from disclosing it to other individuals, to other agencies within the federal government without the express consent of the individual, or in the instance where there might be a legitimate law enforcement question, a written request by the head of an agency like the Department of Justice. So first of all, obviously, if this information was scoured and removed from the federal agencies that have it, it's clear that, number one, Swalwell never gave his consent to it, and we have no evidence that there was a formal written request by a relevant parallel agency for such information. So on its face, it seems pretty clear here that these allegations are valid, right? That the Privacy Act of 74 is likely was violated. Now, of course, this has to be run through a court of law, and the evidence has to be produced. But on its face, it seems not just plausible, as a litigant must show, but possibly this occurred, right? So that would constitute a violation of the 74 Act. The other argument that Swalwell makes, which is super interesting, is that this is a violation of his First Amendment rights, and those First Amendment rights, protect people from retribution for political views. If we go back to really the origins of all of our privacy law, consistent, with the Fourth Amendment and even the First Amendment, the origins of that is, comes from pre-colonial times. In fact, comes from Great Britain, right? So in 1763, there's a famous lawsuit, Wilkes v. Wood, in England, where a member of parliament had his home searched and for evidence of sedition. And there was a warrant there. A judge had issued a warrant, but it was a general warrant. Go find me some evidence, right? And the member of parliament, after his home was ransacked for evidence of sedition against King George III, he brought suit, and a jury found in his favor, saying that this was a violation of his fundamental rights, issuing an order for £1,000 sterling, right, which today is about $300,000 US, right? So this case in Great Britain sort of migrates across the pond. It becomes makes up some of the arguments, even for revolution, right, and for independence, that the king's men in the colonies were engaged in similar conduct here, and looking for evidence of sedition. The insights from that case inform our Fourth Amendment rights, our First Amendment rights. So I think Swalwell's got a pretty strong case here. If we think about both the Privacy Act of 74 and his First Amendment claims that argue that he's being targeted for his political speech, for his opposition to and dissent from the Trump administration. So I think it's going to be a very interesting case. We'll see how it proceeds, and it could have reverberations with some of these other cases as well, if he's able to establish a strong precedent. So let's keep our eyes on this case, because it's a super interesting one.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.